In 2013, a California police officer found out that his girlfriend, Desiree Martinez, had reported him for physically abusing her. This happened while Desiree was trapped in a room with him, leading to further horrific abuse. Incredibly, the informant was another officer who knew about Desiree's boyfriend's history of domestic violence. Desiree later sued that officer informant for enabling the abuse, but an appeals court granted qualified immunity to block the suit. Now, Desiree and IJ are asking the US Supreme Court to make clear that government officials who knowingly place people in danger can be held accountable. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice. Together with co-host Keith Neely, today we're talking with IJ attorneys Anya Bidwell and Patrick Jaicomo about Desiree's fight for justice. This is Beyond the Brief. So Anya, tell us about Desiree Martinez and sort of what happened.
Desiree is the kindest, warmest person you'll ever meet. She was stuck in an abusive relationship with a police officer whose name was Kyle Pennington. And she had a very difficult time getting out of it for many reasons, including trying to protect her daughter. Desiree filed a police report. I'm just thinking about the best way to talk about this. But she filed an anonymous police report trying to get the police department where Kyle was working to do something about it so she could get out of the relationship. Instead of helping her to get out of this relationship, the police department, through an officer, a friend of Kyle Pennington's, actually disclosed that police report to Kyle Pennington. As a result, Desiree was severely beaten and raped by Kyle Pennington. And here's the thing, too. Kyle and Desiree were having this discussion like 3 a.m. in the morning. Kyle was confronting about her telling the cops on him. And she kept saying, I didn't, I swear I didn't. And so to confirm that, he called this police officer, put her on the speakerphone and said, listen, Desiree here is telling me that, there isn't a confidential report, that didn't file a confidential report about me. And this police officer said, oh, no, she did. I have it right here. So that conversation happened at 3 a.m. in the morning. So Desiree obviously is stuck in that apartment. She can't go anywhere. So Kyle hangs up and proceeds to assault Desiree. And the suit really has many different players in it, many different actors, went up and down several times. But what we are on a petition for certiorari for is this phone call and how that phone call led to Desiree being assaulted. And our listeners would know that qualified immunity is a difficult barrier, and this is what happened here. The Fifth Circuit, we are in the Fifth Circuit so often. The Ninth Circuit said that you're right, it's a constitutional violation to put somebody in danger like this. But it said the violation is not clearly established because there aren't other cases with facts identical to this. There are cases where police officers are affirmatively putting somebody in danger. They're just not exactly these facts. And so the Ninth Circuit said, while there is a constitutional violation, while we sympathize with Ms. Martinez, we are, we're having to throw her case out of the court, though victims of domestic violence going forward, given that their facts are very similar to Desiree's facts, would be able to actually point to this case as clearly established precedent. We are now at the Supreme Court saying, listen, when it comes to cases like this, where you don't have a split-second decision-making, at all. This woman, this police officer, worked for a records department at the time she was looking at the report. She wasn't rushed. Her life wasn't threatened. In a situation like that, when you have a case that's similar on the facts but not identical on the facts, you still should count that as clearly established law. Now, with split-second decision-making, there might be a different calculus, but we are not talking about that. We're talking about a situation like this where the officer is just simply not put in that position.
Well, speaking of the facts, and I just want to make sure I get this straight. So it's not just that they disclosed to the officer that she had filed a complaint. They confirmed it with him on the phone with her there in the room, knowing that she was likely going to receive some sort of victimization as a result of this, right?
Confirmed it and also contradicted what Desiree was saying.
My
because
goodness.
Desiree was swearing she didn't file this anonymous report. And our police officer said, no, I have it right here.
And this officer, too, has a history of domestic violence issues. Is that right?
This officer has a history of domestic violence. So the officer who disclosed the report, Shannon High, she knew of that history. She knew that Kyle was on leave, on an administrative leave before. But she also was friends with him. They go back to their days in the academy. So she, there's a history there, and she has a lot of background knowledge of Kyle's behavior with other women, and yet she chose to contradict Desiree in real time at 3 a.m. in the morning and tell Kyle that Desiree did file a confidential report asking police for help.
So she had to know what was going to happen after that phone call, presumably.
Exactly.
So you talked earlier about how part of the problem here is that the qualified immunity analysis sort of makes the court go and see if they can find a case that's kind of exactly the same as what's happened before.
Right.
Just how similar does it have to be? Can you kind of give some examples?
So that's an interesting question because really courts are all over the place on this. And it really is up to the judge and how the judge feels like on a given day, right? Some judges, they really want to kind of reach for the plaintiff. They feel that the case is just manifestly unjust. So they are going to look for a case and they will say, it's sufficiently similar because fundamentally at the heart of qualified immunity is whether the officer was fairly notified. And you can be fairly notified through many things other than precedent exactly on point. But if you don't feel like it, if you're a kind of judge who's like, this plaintiff shouldn't even be here, then you basically can say this case happened on a Tuesday, the other case happened on a Wednesday, fundamentally different concerns involved here, so the law is not clearly established.
Yeah, and so to give a couple examples of how that's actually played out in the more egregious cases, there's a case from the Sixth Circuit, for instance, called Baxter versus Bracey, and that's a case where police let their dog bite a suspect who had surrendered. And in that case, the suspect, when he brought his lawsuit, said, hey, here's another dog bite case where the dog was allowed to bite a surrendering suspect. And the Sixth Circuit's distinguished it by saying, well, in your case, you surrendered by kneeling and putting your hands up. But in that case, the suspect surrendered by laying on the ground and putting his arms to his side. And so it's not clearly established that the law from that case ports over to your case. Or for a more recent example, there's a case out of the 11th Circuit called Benning where prison officials who'd been on notice from the Supreme Court since the 70s that you can't simply rifle through inmate mail without doing some sort of due process, rifled through inmate email. And the 11th Circuit said, well, it's not clearly established because mail and electronic mail are not the same thing. And so you kind of see these hairs being split left and right. And, sometimes, like in the Baxter case, it might be in the use of force in a sort of split-second evolving situation. And sometimes, like in Benning, it won't be. To give another example from an IJ case, in the King case, actually, this was a losing argument, but the government tried to argue that when James King was put in a chokehold, there was no clearly established law violation there because the case that King had cited was one where the person choked was sitting in a chair, whereas James King was laying on the ground. And so, as Anya was saying, there, the Sixth Circuit didn't buy that distinction. But on another day or with a different panel or a different judge, you could easily see an argument that seems ridiculous like that actually winning the day because the clearly established test, as currently interpreted, is so malleable.
And well, in the Ninth Circuit too, right? There's the Jessup case, right, where you had an officer who, falsified warrant affidavits to steal over $200,000 in rare coins, and the court said this is clearly morally wrong, but we can't find another case where an officer stole $200,000 in rare coins in this way. So I guess he's off the hook.
Yeah, well, and we should also point out the Jessup case is one of Kevin Little's, who's our co-counsel here in the Martinez case.
Oh, I didn't know that.
And that kind of goes to show you, I think, what the Ninth Circuit was getting at here is, as Anya said, here they said it wasn't clearly established, but we're going to go ahead and clearly establish it going forward. But in Jessup, they just said it's not clearly established and we're not going to clearly establish it. And so it just kind of shows you all the different ways that the courts can weigh in on these issues and decide them. And I think, another good example is this case itself, because the case that was cited by Desiree was, by any reasonable metric, a clearly established case. Here we have a situation where a police complaint was disclosed to the person who committed the crime, and they came back later and killed some of the people that were involved and shot some others. And it's very similar to this case. And the reason that the Ninth Circuit distinguished it is because they said, oh, well, there was actually an aggravating factor in that case, which was the police told the complainant, we'll be patrolling, and so kind of you'll be safer, right? And so that made that case worse than this. But as we point out, in this case, the officer knew that the abuser was in the room with the complainant at 3 a.m. And so there's even more aggravation. It would be like in that case if the person was in the room with the officer and the victim, and the officers knew that this person had a gun. And so trying to split those hairs here doesn't make sense in a way that any normal person would understand, oh, that's clearly established or that isn't clearly established.
What you and Keith are both talking about, to me, sounds like, whether or not you can find a case that's exactly the same. Some things are just so obvious, either, morally wrong or obviously unconstitutional.
That's a separate doctrine, Kim.
So does that play in at all here?
So here, petitions are very targeted on particular doctrines. You're looking for a circuit split. So in this case, we have a pretty clear circuit split on how the Ninth Circuit is approaching these types of cases and how the Fifth Circuit is approaching these types of cases. So we're really arguing on the level of specificity needed in a precedent, especially because here we have a precedent, as Patrick mentioned, that's very, very, very similar to what happened here, and it doesn't count. So in this case, we don't really raise obviousness point, although we do have a footnote in the petition saying that it also is an obvious violation. This does go to that problem of lower courts really trying to grasp with, okay, when do we look at the obviousness? When do we look at clearly established? Is obviousness part of the clearly established? How do you approach split-second decision-making by police? For example, the Ninth Circuit, when it comes to split-second decision-making by police, is actually pretty, unprotective of police. And the Supreme Court several times reprimanded it for it. And I think fundamentally with the Ninth Circuit, they're saying, listen, when we're talking about excessive force cases, we don't want to be double counting, right? There already is this reasonableness protection in the Fourth Amendment.
Right.
The officer must act unreasonably. So they're saying this whole clearly established law stuff, it's kind of double counting the reasonableness. So we're not really going to be looking for a case law directly on point that's like with strict degree of similarity. Now the Fifth Circuit is the opposite, where the Fifth Circuit is saying, no. Actually, when it comes to split-second decision-making by police, the degree of similarity must be almost exact, because you're talking about the police officer having to make choice in seconds. It has to be ingrained in them, and we're just not going to be second-guessing them, and we don't agree with the Ninth Circuit that we're double counting here. The two inquiries are completely different.
Well, and it bears repeating that all of this is built on this legal fiction that police officers, after a long day of work, go home, they read the latest published opinions in their circuit, they commit them to memory.
And they have their wine, they're relaxing like that.
Exactly. And then so that way the next day when they're on the beat,
they're reading it. Yes.
That they've somehow, memorized it for that split-second purpose.
Right.
But that's, of course, not what's happening in real life.
Right. And I think this, the obviousness question is a good one, because what this case is really about, what the clearly established test is ostensibly about, is providing fair notice. And so theoretically, even though all the empirics prove this is not true, what the clearly established test and what obviousness are supposed to be accounting for in the qualified immunity discussion are, we expect you to not do this because you should know that it's bad. And so in the obviousness case, you're saying, okay, well, even if there isn't an earlier case, you know it's bad for a variety of reasons. This case is one of those cases. It should have been obvious to say, like, well, if you tell the bad guy about the person complaining about him while she's trapped in a room with him, you're doing that knowing that you're doing something bad. This is true also of the Jessup case. Stealing stuff, everybody knows that's bad. And so you should already have that inbound fair notice. But what's sort of remarkable about this case is that even though you have that obviousness, you also have the Ninth Circuit saying, oh, well, even though there is another case that clearly establishes what happened here is wrong, we're going to zoom in on that to such a granular level that even that's not enough to provide this person with notice. And it kind of, I think, emphasizes how sort of mechanical and bizarre the standard is, because nobody in their right mind would look at this set of facts and look at what Officer High did and think, oh, well, there's no way that she could have known that what she did was bad or wrong or would be harmful. Everyone knows, looking at it, that at a minimum, you know that some harm is going to flow from that. And much more likely than that, you were intending that harm to happen here. And so that's what I think the obviousness discussion feeds into in a case like this, where we shouldn't even need to rely on it because we did give a clearly established case, but here we are.
So are you saying that the Ninth Circuit, excuse me, are you saying that the Ninth Circuit sort of followed the pattern that the Fifth Circuit has been using of trying to find this exactly identical?
No, the Ninth Circuit in this issue, on this particular issue, the Ninth Circuit is worse than the Fifth Circuit because, as Anya was explaining, the Fifth Circuit at least takes to heart the concept of fair notice and says, okay, well, what's fair notice to, for instance, a mayor who's deciding to have his opponent arrested is very different from what's fair notice to an officer who thinks he saw a gun and it's dark and it's raining and his life is in danger and he has to make an immediate decision right now. And so the Fifth Circuit looks at those split-second scenarios and says, okay, well, fair notice to the officer in the rain with a gun should be a lot more adapted to giving them the benefit of the doubt. Whereas for the mayor, it should be almost nothing because you have time. You can talk to lawyers. You can think about it. You are not under any direct immediate pressure. And so this case actually illustrates an area in which the Ninth Circuit has a more draconian rule than the Fifth Circuit because this is not a split-second decision case.
So this distinction of was it a split-second decision or not is the thing that the Fifth Circuit does that the Ninth Circuit isn't doing.
That's right.
And we're asking the Supreme Court to say basically, like,
pick a side. Who's right?
Yeah, right. Exactly.
That's exactly right. The Fifth Circuit is good on this, even when it comes to looking at police officers in general, right? For example, that there is a case just from this year, Judge Andrew Oldham wrote for the majority where a police officer lied on a warrant. And the facts, are very policey. The guy is very much doing the kind of police work that we're thinking about the Fifth Circuit being very protective of. But Judge Oldham has none of it, right? He's basically saying, I understand when we need to protect the police. And those situations are not situations where the guy is sitting there writing things on the warrant application. In those types of situations where you don't have split-second decision-making, you don't need a case that's identical on facts.
Right. And by contrast, the way the Ninth Circuit does it, as Anya mentioned earlier, is they have one exacting standard for everybody. And so you could have this sort of
Actually, not one exacting standard for everybody. They're almost more. That's why I was like unprotective of police. Like it's not a good way to kind of phrase it. But the Ninth Circuit actually is not worried at all about split-second decision-making because the Ninth Circuit thinks that the excessive force analysis itself under the Fourth Amendment already provides you with a good degree of protection compared to like a First Amendment case, a Fifth Amendment case where you don't have that analysis of reasonableness baked into those kinds of constitutional violations. So the Ninth Circuit, what happens there is the opposite, where in excessive force cases, qualified immunity is actually denied.
Right.
Pretty frequently. But in cases like this one, where you don't have split-second decision-making, qualified immunity is granted. And while there are really good jurisprudential reasons for it, we think it's just wrong. And at the very least, there is a circuit split. There's a split with the Fifth Circuit on how to approach it. But I think fundamentally it goes to show you that the Supreme Court needs, I know it doesn't want to, but it needs to weigh in on qualified immunity because the lower courts are all over the place on this. I mean, they're struggling. They're even a circuit that adopted a sliding scale approach. You know, there are circuits that look at obviousness as a separate doctrine. There are circuits that are looking at obviousness as part of the clearly established law. There's just so much stuff going on, and it's would be very, very helpful if, the upper management actually came in and said, guys, here's what we're doing.
Right.
To this exact point, actually, this is where the Ninth Circuit's rules show kind of, I think, one of the assumptions that a lot of people have who sort of passively support qualified immunity is wrong. And this is something that we highlighted, IJ highlighted in our unqualified study, which is that because there are so many Fourth Amendment cases, the case law is more clearly established as a general matter, so you can find a more specific case. But if you're applying the same standard to these outlier situations where they're 14th or 1st or other kind of less common constitutional violations, it becomes harder to find those cases to clearly establish them, which means, in effect, and this is what we find in the unqualified study, that in a lot of ways it's actually easier to find the clearly established law when you're dealing with excessive force cases against police, and it's harder to find it when you're dealing with almost anything else. And so you can have a situation where a county road engineer arrests somebody for, driving down the road in a ridiculous way because road engineers aren't supposed to be able to arrest anyone at all, and then it's impossible for the plaintiff to find an earlier case like that, and the circuit court throws your case out for qualified immunity.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
I want to talk a little bit about the state-created danger doctrine, because what's a little bit unique about this case is that, this really isn't about what Officer Pennington did. It's the fact that Shannon High didn't do something that maybe she should have done, right? She should have recognized this is a dangerous situation. If I tell him what's going on, someone's going to get hurt. And
she kind of used almost Kyle as an instrument. In a way, you could think about it that way, right? It's not like that she stayed away when Desiree was in trouble. It's more she actively conveyed information to the perpetrator that then activated the perpetrator.
At a minimum, you can't be surprised when you put the bowling ball down the staircase that it smashes grandma's clock,
But, so maybe the state-created danger doctrine isn't at play here, but, some listeners might be familiar, of course, with what happened in Uvalde, right, the horrific school shooting down there. Courts have been saying, look, you don't have a right to be protected from danger by the police. Is that an issue in this case? And if so, how does the cert petition address it?
So it's not an issue in this case, though I understand what you're talking about in terms of state-created danger. And there is like this very famous phrase by Judge Posner, and it's about like throwing a person into a snake pit, right? And like there is a difference between, you are not doing something versus no, you are doing something. You're throwing them in a snake pit, and then you're saying, listen, those are the snakes who beat the guy, not me.
Right.
But in this case, we specifically don't address the state-created danger disagreements between the circuits at all, because in the Ninth Circuit, they specifically said that there is that constitutional right. And it's not at issue at all. The only thing that's at issue is, given that there is a constitutional right, is it or is it not clearly established?
I see.
Given that we have this precedent that's extremely similar, like Patrick discussed. They told the neighbor that the woman filed a report against him, and the woman is like, what are you doing? He's going to kill me. And they're saying, don't worry, we're going to patrol the streets. You don't have to leave tonight. You can leave tomorrow, and they end up not patrolling the streets, and the neighbor goes and shoots her husband. So that case is very clearly...
So just to be clear, I think every circuit, maybe with the exception of the Fifth Circuit, has recognized that the state-created danger doctrine is a thing. Is that right?
Yes, that's right.
Okay. So this is not the subject of the split here. Here we're focusing solely on what is and is not clearly established. We're all in agreement, or at least for the purposes of this cert petition, we're all in agreement that the state-created danger doctrine is a thing, and it would have applied in this case.
Absolutely. The real question is, with any constitutional violation, given that the court agrees there is a constitutional violation, then how high or low do you look for precedent to confirm?
Right.
And to hold that it was clearly established and the officer had fair notice.
Gotcha.
So, Patrick, this case has been going on for 9 years before IJ kind of found it and got involved. Is that normal for it to take this long?
Unfortunately, every case that involves one or more immunity doctrines is going to almost always take a really long time if the government decides to press those issues. And so it's normal in the sense that this is the normal we exist under because the courts have created things like qualified immunity, which muck up the gears. And the irony is that qualified immunity, one of its stated purposes was, well, we want things to get over quickly. We're worried about insubstantial cases. And so we're going to do all these things. We're going to create this doctrine. We're going to add procedural additional checks that the government can use to appeal things immediately and so on and so forth. And the reason is we think that this is going to take away the attention of government workers from their jobs. And we think that by doing this, we can get these cases over more quickly. And the reality is that these cases take a lot longer. These cases will routinely take a decade or more to actually litigate because there are so many difficult issues that end up being appealed. There can be oftentimes multiple appeals in these cases. And this is another thing that IJ's study, Unqualified, on the qualified immunity doctrine found, which was that these cases that have qualified immunity appeals on average take about 23% longer than what you'd expect for another similar case that wouldn't have those sorts of
23% longer just doesn't sound right when it comes to cases that we're litigating. Like, for example, the Gonzalez case that went all the way to the United States Supreme Court. 5 years later, we're finally getting to the district court to see what's going on. I mean, King took forever. You were a baby lawyer when you took it up, and it's still going.
We're past 10 years beyond when the incident took place, the Hamdi Mohammed case. Her and Ifra were unjustly arrested by Heather Waker in 2011.
In this case, too, so a kind of really good demonstration of why it takes so long. So in this case, there are actually several defendants. As you can imagine, Kyle Pennington is one of the defendants, right? Mm-hmm. And the district court originally said no qualified immunity to any of the defendants. And then some of the defendants took it up on interlocutory review, which is something that only government defendants can do. And they said, hey, we lost at the district court, but that's not right. You have to, reassess and grant us qualified immunity. So Shannon High was not one of the officers who took it up on interlocutory review. She kind of waited in the district court. And when those defendants got qualified immunity granted to them on appeal, that's when Shannon High was like, me too. And so then a briefing for her began, right? And that was basically another round of appeals. And appeals take a very long time. I mean, a year at least just to get through one court of appeals. Yeah,
as anybody who's litigated these cases and then other cases knows, the process for going to trial in a normal case, if you were just arguing over a business dispute, for instance, is going to be a lot more simple and streamlined and a lot faster than having to fight through all these immunity doctrines and then basically starting from scratch and going through the same process that you'd see. And so basically what these immunity doctrines do is they take the normal process and they adorn it with a bunch of things that cause additional delays and additional appeals. And the takeaway is that it just becomes a lot more difficult for plaintiffs to litigate these cases. And the secondary takeaway is it becomes a lot harder to find attorneys who will represent folks, because if you're an attorney, you're often going to take these cases on a contingency basis, so you don't get paid unless and until you win. And if you're looking at a case where you can resolve a business dispute in 6 to 12 months, or one where you can have a civil rights fight for the next 12 years, a lot of rational attorneys are going to say, no, thanks. I'll focus on the second-tier automotive supplier cases and not the government abuse cases.
Yeah, I mean, I think you're pointing out an important thing there where, even assuming the Supreme Court takes Desiree's case and rules in her favor, that's kind of just the beginning of the story somewhat, right? Then she actually goes to trial against Shannon and all of this, and then
exactly, it's
that
by
plays
no
out
means
for more years.
It's by no means over. That's kind of how these cases operate. With Sylvia Gonzalez, for example, great victory in the United States Supreme Court, but now the actual real fight begins.
Yeah, and I do want to put a button on this because I think it's important, especially for the lay audience. Normally the way a lawsuit works is you file something called a complaint, and then the other side files something called an answer, and then you go through a process called discovery where you ask each other questions and answer them, and then after discovery you go to trial. That's kind of the basic way that litigation normally works. And to show you how delayed this can be in these immunity cases, both of the cases that our project has taken to the U.S. Supreme Court, King and Gonzalez, those cases were heard by the U.S. Supreme Court before the government filed an answer in the case, which is step one that I just laid out of the 3 steps of litigation. And so that just goes to show you that oftentimes you haven't even really started litigating the case before these things are able to muck up the works.
That's why it's really amazing when lawyers like Kevin Little take on these kinds of cases, fully realizing how long it will take. And you mentioned that Kevin was also on the
Jessup case.
The Jessup case. And that's actually not surprising. We see repeat players in this area. Hugh Eastwood is another one. He is an amazing civil rights lawyer in Missouri. And I really don't know how those guys do what they do.
Well, that's what I was going to ask
my
you.
heroes.
How can they afford to do that? I mean, IJ takes all of these cases and we represent people for free, and we have 10,000 supporters that make it possible for us to do that. How are these kind of private practice guys able to do these things?
Often their work against corporations and hospitals and you name it subsidizes essentially their work on behalf of civil rights clients. And it's really a matter of them not being able to stay away. Like with Kevin and Desiree, he calls her a hero, his personal hero, and he has a very, meaningful relationship with her and wants to do everything that he can to ensure that she gets justice.
It's very rare to see a practice where a plaintiff's side attorneys are able to kind of make a lot of money doing these cases and these cases alone. And so that means that there really has to be some amount of genuine care and passion put into this stuff, because if you want to have some sort of legal get-rich-quick scheme, it's not going to be in civil rights litigation.
In fact, I think Joanna Schwartz has written about this, how there's just kind of a dearth of good civil rights lawyers in the country identifying some of these very same sorts of problems. How did Desiree react when IJ got involved in her case and agreed to help take this to the U.S. Supreme Court?
Desiree was extremely happy, and she knew about IJ, and she was very grateful to have this opportunity to work with us. But really what clinched the deal, in a way, if I can even put it that way, was that Kevin Little trusted us. And she has a very meaningful, long-term relationship with Kevin. So when he says, Institute for Justice is going to step in at this point, and we're going to do this one last attempt at Shannon High and keeping her accountable, then she says, Kevin, I trust you fully, whatever you think is best. So a relationship that we have is with clients, yes, but also with those amazing lawyers, like also William Most in Louisiana, who we work with, on a regular basis, whether it is getting involved formally or even talking about this kinds of stuff informally. And if any of these lawyers are listening to us right now, please keep filing those cases, keep bringing those challenges. And the Institute for Justice is here to help you with them, and also, if need be, to take over temporarily. Get those doctrines out of the way, so then finally you can get the case to the jury.
I think we're just about out of time, but really quickly, we've talked a lot about qualified immunity here, but it's, just one of the many sort of immunity doctrines that kind of keep people from being able to bring these cases. So can you quickly kind of highlight a couple of these?
That's a great
things?
last question.
Ready to go. Just list the
We'll be here for another 30
We're
minutes.
almost out, but give me this litany of things. Ready to go.
Yeah, I mean,
30 seconds.
So of course you have qualified immunity, you have prosecutorial immunity, which is absolute. You have judicial immunity, which is absolute. You have restriction on a cause of action against federal officials, which we call federal immunity, which is getting closer to absolute. You have a lot of things that aren't actually called immunities, but are actually immunities. So the issue in our Gonzalez versus Trevino case was one of these, where the courts had concocted a way that you couldn't bring First Amendment retaliation cases. There's another one called Heck versus Humphrey that is a huge issue in another prosecutorial immunity case that IJ is litigating right now, which says that if you've been convicted or sentenced for something, you basically can't challenge it through a lawsuit unless you get that conviction set aside in some fashion. And so there really is, when we started this project, we had a few of these immunities as stated targets. And then as we litigated this for years and years and years, we just kept finding them under every rock we flipped over. And so the list of this, which you can look at on our website, and we'll just continue getting deeper and deeper, if I have to guess, over the next 5, 10, 15 years, is already quite long. And each one of these things can pose a stumbling block. And the real frustration is that in a lot of cases, there will be more than one of these doctrines. And sort of what ends up happening often is, you'll be able to overcome one, and the court will sort of split the baby and say, oh, well, too bad you didn't do the other one instead, because that would have been the way that you really could have prevailed here. And it always just feels to me like that seems to be a convenient out in these cases, and that's the way the government uses them. And the result is that a lot of Americans end up having their rights violated, and they have no remedy in American courts. And I think fundamentally that would be shocking to anyone who understands the way that our constitutional republic is supposed to operate.
So how do you approach fighting all of that kind of, at a big picture level? If the target is kind of constantly changing and things like that, what is sort of your, overarching approach to dealing with this?
Well, it's really be prepared for whatever they throw at you. And sometimes it can be an expected type of litigation where you think, oh, if I were the government, this is what I would raise. But sometimes it's unexpected and very interesting. And we are ready to tackle all of it. That's why it's important for us to kind of have a comprehensive understanding of these various barriers between the plaintiff's claim and finally that claim getting to the jury. It's almost like the track and field theory of immunity. Where there are just so many obstacles before the plaintiff actually can come to the jury with the claim. For all the budding lawyers out there, take Fed courts. Fed courts is really about all the doctrines that make it extremely difficult to sue in federal courts. And it's something that a lot of students stay away from because it's very difficult. But fundamentally, it's about denying a person their constitutional rights without explicitly saying so. Isn't that lovely? It's a passive-aggressive way to deny constitutional rights.
That's it for today. Thanks again for watching, and don't forget to subscribe.